All right, CC students, before we move on to the next concept, which is the facts of the case, just a quick review. Trial is a disagreement between two parties. They're asking for a neutral third party to resolve their disagreement. That can be the court, and it can either be a judge, and that's a bench trial, or a jury, and that's a jury trial. Two types of cases that are heard by courts. Criminal cases, that's where the government is alleging that someone broke a law. And in that case, the parties are the prosecutor is the prosecuting attorney, and the defendant is the person accused of the crime. Civil cases is a citizen against another citizen, alleging that someone did something or failed to do something to them, and it's usually a person against another person. Civil case, not a violation of the law by the government, but a violation of something that this person has done. So those are our quick review about what we should know so far. Next concept, facts of the case. Well, we just talked about this. This is a trial's disagreement between two parties. They disagree about something. They see things two different ways. They both witness an event in some cases, but their perception of what occurred is completely different. They saw it two different ways. Now, the disagreement about the version of the case is what makes up a trial, right? Because the disagreement is between two parties, and the basis of their disagreement is what makes up a trial. And why can they have two drastically different stories about the same event, or versions about the same event? Well, sometimes there's a logical explanation for that. Sometimes it's people, where they're viewing something, their ability to see it is obstructed. Sometimes they're too caught up in the emotion that they can't see it the same way. Sometimes they're lying because they have an interest in the case. Sometimes they made a mistake. Sometimes they were careless. So their version of the events might be impacted by those things. So there's a variety of reasons. So when people have a disagreement, we use testimony, right? We present the testimony in court to come to a resolution. And either the judge or the jury, the trier of fact, they need to find out what actually occurred. We want to get to this one thing right here, the truth. That's always trying to seek the truth in a case. That's what we're trying to arrive at. What is true? So how do we help a judge or a jury get to the truth? Well, we use something called evidence in court. And evidence, the three basic things that make up evidence is testimony, documents, and physical evidence. So let's talk about each one of those individually. First, testimony. We break testimony into two areas. We have testimony by lay witnesses, LAY witnesses, and testimony by expert witnesses. So what are the difference between a lay witness and an expert witness? And when we talk about testimony, we mean a witness comes into court, they raise their right hand, and they're going to talk about what they saw or what they believe in some cases, okay? So let's just talk about a lay witness. These are what people saw. Let's say your case involves a murder and someone witnessed a murder. A witness to a murder who's not a doctor, who's just a normal person who saw a murder occur, can testify what they observed, what they felt, what they heard, what they saw, who did it. That's all lay testimony. It's the who, what, when, where, why, how, those types of things they can provide to the court. And we accept this testimony if a person is credible, right? If the witness, what we mean by credibility is they're not lying, they're an honest person. And we'll get into that on cross-examination about how you can discredit a witness, but let's just assume the witness is not lying. They're coming in, they're going to say what they saw. No specialized belief. Usually lay witnesses are people that were at the scene of the event. That's important. They were there. They saw it. Or they were there after the fact, and they're going to testify about what they saw after the fact. Okay, so those are lay witnesses. Next, we have expert witnesses. What's an expert witness? Usually expert witnesses don't ever go to the scene of the crime. Usually they have no personal knowledge about what occurred. But they are receiving information from a third party, usually the police, in the form of like a police report, or they're looking at a case of a murder, they're looking at a dead body. And based on their training and experience, they can testify about what they believe occurred within some type of medical certainty or based on their opinion as an expert. They have some specialized training or skill that makes them able to look at facts after the fact and formulate an opinion as to what occurred. Why do we let these people come into court and testify if the juries are the one that are ultimately deciding what occurred, right? Why do we let them? Well, their main point is to come in to help us understand things. There's complex things that happen in the law, and we need, for example, we don't all know, we're not all doctors, so we don't know the background about what happens to a human body when someone dies, or the reason someone has died. We might not know that. But we would expect a doctor to come in, be able to look at a body, come in and bring their report in and testify as an expert. This is what caused the death. So these are experts. The person that witnesses a murder can say, I saw someone shoot them and then they were dead. They can also come to that same conclusion, but the only reason they're able to do that is because they actually observed it. An expert didn't actually observe the crime occur, but they can, after the fact, put all the information together and formulate an opinion. We use in the law, we say a saying called garbage in, garbage out. If the expert has bad information and they're using that to formulate an opinion, then their opinion could be wrong. Just tuck that away for later when we talk about cross-examination. So they're getting information from somewhere else. They're formulating an opinion about what occurred. That's expert testimony. Documents. Documents are, you know what a document is. It's a piece of paper. It could be your mock trial notebook. Documents that is provided to you. It could be the form of photographs. It can be witness statements. It can be reports. Those are all documents. That's all evidence. Now, you can't, in your mock trial, just say to the judge, here's the document. You need a person that prepared the document to testify. And when we get into the rules of evidence and how we present evidence, we'll talk more about that. But a document prepared by a police officer, you would bring the police officer into court, and if you want to use his document, his police report, you have them testify to that and talk about it, what's in their document. And that helps the jury or the judge make a determination about what occurred. Finally, we have physical evidence. Sometimes that's the actual firearm that was used in a case when somebody was murdered. Sometimes that's the actual drugs. Sometimes that's clothing. But those are pieces of evidence. And all of these things, whether it's testimony, documents, or physical evidence, all of those things are used by the judge or the jury to help them come to a conclusion about the truth, what occurred. So remember, we have a disagreement between two parties. People have different stories about what occurred. And now we have some evidence that's going to support the story or discredit the story in the form of testimony, documents, and physical evidence. This will all make sense to you in a little bit when we start talking about breaking the case down individually, but this is just an overview. Thank you.